Memorandum on brief statements by a judge announcing his or her ruling. So these are multiple rulings from multiple different judges, all right? And although I will be able to quote some of these cases and where they had happened, unfortunately, a lot of the following information is unpublished cases. And that's one of the interesting things about the judiciary. When a case threatens to compromise the integrity, quote unquote, of the slavery system that they've got in place, for which they're administering the national bankruptcy, they will side with the man who did his research. They will find in his favor, but so often what will occur is that the cases themselves will not be published. Now, I had a guy tell me one time he'd won a case. I asked him for the verified proof of it. He said, unfortunately, the case had been sealed. I recognize that they do that. And I said, okay, I understand that. I went and did some due diligence. I reached out to a couple of my mentors and I explained the situation. Hey, this guy's got a really cool story about a case that he won. Unfortunately, he cannot bring forward any verifiable evidence or proof that it ever existed or happened because the court case was sealed. And what one of my mentors said is, Derek, you realize that if he's a real party to the action, they can never stop him from getting certified copies of the case, the rendering, and the ruling. So I called the guy back up. I said, hey, just to let you know, I believe what you're saying. I understand that you believe that it is sealed, that you can't go back in there. They're not going to release the record to you. However, I have it under good authority that you're a real party and interest in the matter. And although the case is sealed from the public, quote unquote, you're a real party in interest and you can demand and compel them to print out the entirety of the case, including the finding of facts and conclusions of law, because you are the real party in interest. And although it is sealed to the public, it is not sealed to you. So I took one of my mentor's own advice, and I went down the same day this gentleman went down, because I have a number of court cases that are sealed as well. And I walked in and I told him, look, I want this case printed out. And the clerk of the court said, I can't do that. The case has been sealed. Nobody has access to the record anymore. And I said, I think you better call somebody, because I'm a real party in interest in this matter. And I demand that case be printed out in its entirety. All the evidence, all the fucking documents, all the pleadings, I want it all. Depositions, the whole fucking 9 yards, I want it all. The transcripts, everything. She went back into her office, called the judge in chambers. The judge said, give him what he wants. Now, these clerks are pretty snarky most often. They don't like being wrong. They don't like you challenging their presumed and assumed perceivable authority, right? And she came back and said, judge says that I can do it, but you have to pay for it all. Well, that brought up an argument of payment and what you expect, and I can't rightfully give you something that you can't clarify, yada, yada, yada. It turned into a long, drawn-out mess, because that's the kind of asshole that I am. I have no problem giving you what you want. Just define it, please. Go ahead and tell me that you want Federal Reserve notes. Go ahead and tell me that. Just utter it out of your fucking mouth. Just go ahead and let me catch that on camera, what exactly you're asking for, because I find it fucking preposterously funny that when you ask them to quantify and clarify exactly what they're asking, very specifically, with particular details, all right, they can't do it. They can't fucking do it. So you're asking me to give you what perceivably is an impossibility because you will not clarify what you want. Derek, you know what money is. You know what a check is. You know what this is. You know what a debit card is. You know what these things are. I said, I know what they are, but does it constitute a payment? I need to know specifically what you're asking for. Everything that you just mentioned are nothing more than methods used But those terms don't identify a payment. They identify a procedure or a method used to do something, but they don't necessarily constitute a payment. Okay? And, goes back in the chambers, calls the judge up. Yeah, he's being difficult. Whatever the hell she says to him. At the end of it, I get him. No cost at all. Woo, amazing, wonderful, because nobody can clarify or specify what they want for production of documents. And because they can't do that, they create an impossibility which liberates the purported or alleged debtor. Real simple shit, okay? These cases that I don't know who came across them, all right? And to be able to verify them and validate them in a lot of sense, you would actually have to know the real party in interest, which the names are here. The court case number is here. I have reason to believe that anybody that was real persistent could contact these people and get them to go back in and if they're still alive, and get certified copies of all this to validate it. But because I don't have that, take everything that I'm about to talk to you about with a grain of salt, because it is nothing more than hearsay. We have no presentable or material facts that conclusively prove that these were, in fact, the rendering decisions of the people sitting on the bench. But I find it very, very entertaining because the words that they use lead me to believe that it was somebody sitting on the bench making these conclusions. Which brings me to my next point. People need to stop talking about case law. There is no such fucking thing as case law, okay? There is case precedent. Nowhere in the Constitution, Bill of Rights, legislation, Congress assembled, House, Senate, floor, whatever. Nowhere will you ever find that the judicial system or the judiciary or a judge can make law. Nowhere, okay? So the misidentification of court cases being ruled on and rendered is the opinion of sometimes one or multiple magistrates. It's their opinion, and it is not law, okay? It's case precedent. It's their opinion of how they viewed what purports to be the law, all right? So let's get started understanding these facts. When somebody's trying to say, this is case law, objection, hearsay, speculation, see no facts and evidence on the record proving that there's anything that exists that's called case law. Okay, that's presumption and assumption. I'll recognize the case as maybe setting a case precedent to some degree, but there is no judge, magistrate, esquire, chancellor that has the ability, that is authorized by the Declaration of Independence, the Federalist Papers, the Constitution for the state or the United States. There, furthermore, is no evidence in Congress assembled that any judge, anybody in the judiciary has the ability to make law. All right? So, let's get started. These are memorandums on brief, statements by a judge announcing his or her ruling. Again, these are multiple different cases. Lends to jurisdiction is the first subject matter. Patterson versus Deemer, D-I-E-M-E-R, 35 Ohio, ST, 3D, 68, 518, N.E.2D, 941. This case happened in 1988, so it's quite possible that Patton, P-A-T-T-O-N versus D-I-E-M-E-R, they're both still alive. There's a possibility of that, all right? A judgment rendered by a court lacking subject matter jurisdiction is void ab initio. Consequently, the authority to vacate a void judgment is not derived from Ohio Revised Civil Procedure 60B, but rather constitutes an inherent power possessed by Ohio courts. I see no evidence to the contrary that this would apply to all courts. 2. A party lacks standing to invoke the jurisdiction of a court unless he has, in an individual or representative capacity, some real interest in the subject matter of the action. Lebanon, L-E-B-A-N-O-N, Correctional Institution versus Court of Common Pleas, 35 Ohio, ST, period, 2D, 176. This case happened in 1973. Now, neither one of these cases purports to be sealed or failed to be published publicly. But this next case that I'm about to read to you is purported to have never been published publicly. And so this is one of those instances where we would want to go find the real party in interest and ask them if they would mind going down to the local clerk of the court and getting the full case file jacket, including the finding of facts, conclusion of law, and the decision made by the magistrate or judge or chancellor or whatever the hell you want to identify him as. A party lacks standing to invoke the jurisdiction of the court unless he has, in an individual or representative capacity, some real interest in the subject matter of an action. Wells Fargo versus Byrd, B-Y-R-D, 178, Ohio, appellate level, page 3D, appellate 3D, 285. This case happened in 2008, Ohio, 4603, 897, N period, E period, 2D, 722. This case again happened in 2008. It went on to hold, if plaintiff has offered no evidence that it owned the note and mortgage when the complaint was filed, it would not be entitled to a judgment as a matter of law. The following court case was unpublished and hidden from the public. Okay? So, I have all these posted on my Facebook wall somewhere. The reason I'm reading them is because I understand that people are busy in their day-to-day events in life and working, and sometimes this is the best way to stay current and to gain acquired knowledge. So again, I comprehend why this case would have never been published. Okay, this is great foundational work for destroying the idea that some bank has standing to bring a suit. Okay, it says, and I quote, it went on to hold, if plaintiff has offered no evidence that it owned the note, in constructive possession of the note, and mortgage, okay, together, the note and mortgage together, when the complaint was filed, it would not be entitled to a judgment as a matter of law. That's great. It's good stuff. I see no facts and evidence, and I see no presentable material and facts and evidence that the plaintiff has the mortgage and is in constructive possession of the note, granting this court jurisdiction, right? Because the plaintiff, the moving party, the alleged real party in interest, has not presented to this court that they are the holder of the note and the mortgage together. And because of that, I move to dismiss for a frivolous claim for which relief cannot be granted because the burden of proof, the onus of probandi, falls on Wells Fargo Bank. All right. And this court held that that was true because it was now a matter of law. And I believe I like this statement at the end of that. And I believe no evidence exists in material or presentable form, okay, to the contrary. You say that, and now it makes it a matter of law. And I think this ruling is beautiful. And I also feel that because of this ruling that happened in 2008, remember during the great financial crisis that is the same as what happened in 1908, the following court case was unpublished and hidden from the public. Why? Because as judges sitting on a bench administering a national bankruptcy, they have a duty to protect the public trust, okay? They have a duty to keep the facade going that somehow you owe something. And a case like this would be drastically devastating to Freddie Mae, Fannie Mac, U.S. Bank, Wells Fargo Bank, so on and so forth. So what do? They cut this man loose. They cut the strings. They say Wells Fargo doesn't have the grounds or standing to bring claim. And then they naturally do not publish it publicly because they don't want all of you guys seeing this stuff. Okay. Wells Fargo, Littleton Loan versus Farm, 876. New York State 2D21, this case again in 2008. Wells Fargo does not own the mortgage loan. Therefore, the matter is dismissed with prejudice, meaning they can't bring it. Hold on. My recollection. I can't remember if it's with prejudice, they can't bring it back, or without prejudice, they can't bring it back. You'll have to do your own due diligence. It seems to evade me at this moment. The following court case was unpublished and hidden from the public. I wonder why. Case number 5, Wells Fargo versus Rise, R-E-Y-E-S, 867 New York State, 2D 21. This case again, 2008. Dismissed with prejudice, fraud on court, and sanctions. Wells Fargo never owned the mortgage. The following court case was unpublished and hidden from the public. Number 6, Duchess Bank versus Peabody, P-E-A-B-O-D-Y, 866 New York State, 2D 91. The case was had in 2008. Equi first. When making the loan, violated Regulation Z of the Federal Truth in Lending Act, Title 15, USC subsection 1601. I'm very familiar with Title 15, by the way, and you all should become very well acquainted with it as well. And the Fair Debt Collection Practice Act under Title 15, 1692. Yeah. The 1692 was a declaration and finding of Congress, okay? All right, very, very important to understand who made that declaration that gives all the power, weight, force, and effect to Title 15, 1692. It's a declaration and a finding of Congress about unfair and deceptive trade practices, okay? Intentionally created fraud in the factum and withheld from plaintiff vital information concerning said debt, and all of the matrix involved in making the loan. Full disclosure wasn't had. Ooh-wee! What do we know about a contract? If full disclosure isn't had, the contract is void in ab initio from the beginning. Failure to disclose. And the one who makes the contract bears the burden, okay? So that's why we always like to let the prosecutor make the offer. He bears the burden if he uses false, fictitious, conveyance of language, or language that is vague and ambiguous without providing full disclosure. The one who created the contract ultimately becomes liable for it, all right? Very important. With prejudice, it can't be revisited. Thank you, Brian Parker. I appreciate you, brother. Thank you. It just seemed to elude my mind there for a minute. The following court case was unpublished and hidden from the public. Again, these are court cases. They're hidden. I've just explained to you that if you can find these people that were involved in these cases, they had the power and authority as a real party in interest to go get certified copies, all right? Whoever put this together, I'm guessing, was on the inside and had access to records that many of us are not privy to. Pretty cool that they put this all together, doing their research, and released it to us, all right? IndyMac, I-N-D-Y-M-A-C, Bank versus Boyd, B-O-Y-D, 880, New York State, 2D, 224. This case was in 2009. Again, we're going through the house crisis bubble, all right? To establish a prima facie case in an action to foreclose a mortgage, the plaintiff must establish the existence of the mortgage and the mortgage note. Remember, if the note and the mortgage are not put together at closing and they are separate, there is no mortgage. Okay, there is no note. It's void in ab initio. There is no binding contract. It's an absolute, complete dissolution of what may have once been, but clearly exists no longer. When the note and the mortgage are not together and are separated, it voids everything. It is the law's policy to allow only an aggrieved person to bring a lawsuit, which means the man or woman, the real interested party, having the note in their constructive possession as well as the mortgage, is the only one that truly has standing to bring a claim. A want of standing to sue, in other words, is just another way of saying that this particular plaintiff is not involved in a genuine controversy. They're not coming into the court with clean hands, okay? It could be presumed and assumed at this point that they're engaged in an egregious action or engaged in an egregious action that would lead to one to believe that extortion is afoot, okay? And is simply syllogism, syllogism, takes us from there to a jurisdictional dismissal. So the court's admitting that it doesn't have in personam jurisdiction, subject matter jurisdiction, or territorial jurisdiction because the way the claim was brought, there's no presentable or material facts and evidence that lead this court to believe that the one bringing the claim is coming with clean hands and has standing or cause of action. So this case has been brought forward frivolously, for which no relief can be granted and therefore is dismissed. Number 8, the following court case was unpublished and hidden from the public. Again, it's hidden from the public for a reason. All right, they have a duty to protect the public trust and to keep the facade going. They don't want the mindless masses to realize how much power they have. IndyMac Bank versus Bethley. All right, and this is what happens. You notice the last case was IndyMac Bank, and again, that case, the last case was in 2009. Well, I'm guessing Bethley turned around and heard about IndyMac versus Boyd and got her little feet wet and said, "Hey, wait a minute. These guys purportedly hold my mortgage and note too. I'm going to go ahead and bring suit." Even though the other case wasn't published, it may have been known of in the paper. And so now IndyMac versus Bethley arise because Bethley's like, fuck it. If Boyd won, I should be able to win too. This is why they don't publish these cases. So here comes Bethley, 880, New York State, 2D, 873, same year, 2009, probably shortly after Boyd won his case. Bethley says, fuck you fuckers. The court is concerned that there may be fraud on the part of the plaintiff. So the plaintiff would have been IndyMac Bank. So they were too dumb to stop while they were ahead at this point. They went ahead and brought another suit after losing to Boyd. And Bethley says, yeah, I got this shit good. I'm gonna go ahead and ride the same wave Boyd was riding. So in 880 New York State 2D 873 in 2009, the court is concerned that there may be fraud on the part of the plaintiff, or at least malfeasance. Plaintiff IndyMac, Duchess Bank, and must have standing to bring this action. They are shutting IndyMac Bank down. This one's about to go belly up, ladies and gentlemen. All right? And again, this is in 2009, but these cases set case precedent. They don't make case law because they're not authorized to make law, but they do set case precedent based upon the facts leading to standing, jurisdiction, subject matter, in personam, and territorial jurisdiction, all right? The following court case was unpublished and hidden from the public. Gee, I wonder why. Dutch Bank National Trust Co. versus Torres, Torres, New York Slip OP 51471U in 2009. Again, during the housing bubble crisis with Freddie Mae and Fannie Mac. That the dead cannot be sued is a well-established principle of the jurisprudence of this state. Plaintiff's second cause of action for declaratory relief is denied. What are they telling you there? You can't sue the dead because the dead doesn't have an opportunity to clear his good name. So thus, if you are dead, nobody can bring a suit against you unless they have the contract written up and all that good jazz. Obviously, somebody tried to bring a claim against a dead guy that didn't have any physical or material or presentable evidence that they had engaged in a contract prior to the party being deceased, and thus the court had no choice but to render that the action could not be granted because the man doesn't have the capability of defending his good name. And they're not going to allow his good name to be soiled based upon hyperbole, hearsay, and rhetoric by somebody who claims to be aggrieved when the other party cannot defend themselves. Okay, and that's just logic and good sound doctrine and principle as far as I'm concerned. To be entitled to default judgment, the movant must establish, among other things, the existence of the fact which gives rise to viable claims against the defaulting defendant, meaning there had to have been some kind of contract in place, some type of agreement that was in written form, provable, verifiable, under the pains and penalties of perjury, or signed before a notary, or multiple witnesses that saw it that can testify to the veracity of the claim and standing of the plaintiff making the action, okay, calling for relief. But that wasn't the case. They didn't have it. I agree with this court. The doctrine of ultra-vires is a most powerful weapon to keep private corporations within their legitimate spheres and punish them for violation of their corporate charters. And it probably is not invoked too often. Zinc Carbonate, Carbonate Co. versus First National Bank, 103 Wisconsin, 125, 79 NW 229. This case was had in 1899. See also American Express Co. versus Citizen State Bank, 181 Wisconsin, 172, 194 NW 427, 1923. So that's interesting because it's between corporation and corporation. You can't sue the dead. Interesting. The dead cannot be sued. Very interesting. Number 10, the following court case was unpublished and hidden from the public. Wells Fargo versus Reyes, R-E-Y-E-S, 867 New York State, 2D, 21. This case happened in 2008. Okay. Case dismissed with prejudice, fraud on the court, and sanctions because Wells Fargo never owned the mortgage, nor the note was lost. Now, when the bank is claiming that they lost the note, you cannot let them off with that bullshit. All right, you have to stand up and object to them having any standing. If they lost the note, that's on them. That's their fucking problem. But we know they didn't lose the note. Can we prove that they didn't lose the note in court? No, we can't. But their admission that they don't have the note proves that they don't have standing. Can we prove that they sold the note? Maybe. We could do some intelligent intellectual work and hire investigators and do the MoneyNet Daily Log Transaction Report 120 and see who the note was sold to, who purports to hold it, on and on and on and on and on and on. But it really doesn't even need to go that far, does it? Because through their own admission, they claimed and purported to have lost the note, yet still are claiming to be entitled to remedy. And the court making this decision was spot the fuck on, because now the claimant doesn't have any standing. They shouldn't have lost the note. That's on them. They bared the burden by not keeping an accurate record and holding the note, and then bringing a claim, which is, as far as I'm concerned, is fraud on the court. Whether or not they were sanctioned for it or not, it does purport that they were sanctioned for it. The attorney for Wells Fargo knew damn good and well he shouldn't be bringing a claim. So there were sanctions brought. Whether it was on the lawyer or Wells Fargo, I don't know. It says on Wells Fargo, but I would say that the lawyer carries the primary active degree of fault because he knows better. 7 years of law school plus all these fucking seminars, and you don't know that you can't bring a claim if you're not the fucking holder in due course. You don't hold the fucking note. That guy should have been sanctioned too. Bar grievances should have been filed against him. Should have went before a judicial committee and board on disciplinary actions. And these are things that we should all be cognizant of. The ability to compel an investigation into their nefarious activities to unjustly enrich themselves, which constitutes baratray. If you don't know what baratray is, go look it up. 11. The following court case was unpublished and hidden from the public. Wells Fargo Littleton Loan versus Farmer, 867 New York State, 2D 21, 2008 was the case. Wells Fargo does not own the mortgage, loan, nor the note. Indeed, no more than affidavits is necessary to make the prima facie case. Now, what is prima facie evidence? Prima facie evidence has the appearance of evidence, but if challenged under the greatest scrutiny, and it doesn't even have to be greatest scrutiny, it could be the slightest fucking scrutiny as far as I'm concerned. A negative averment is a challenge under the slightest bit of scrutiny that you're willing to testify to under the pains and penalties of perjury, and even subject yourself to, dare I say, a lie detector test. Okay, people go, oh, those are inadmissible. Hey, I'm willing to stipulate to it. I'm telling you that these facts that I present in the negative averment, affirmed with a positive affidavit or statement of facts, sworn to under the pains and penalties of perjury, I am willing to stipulate to a polygraph test because I'm so serious about the nature of my claim. Is Wells Fargo willing to stipulate to a polygraph test? Is the lawyer for Wells Fargo willing to stipulate to a polygraph test? Because I am. Quid pro quo, baby. Put your money where your mouth is. Put your nuts on the chopping block. Let's do this thing. Let's put our testes where they matter, right? Testify to testify is to put your testes on the chopping block, all right? United States versus Chris, 658 F period 2D 526, 7th Circuit Court. This case happened in 1981. It's plausible that the parties involved in this case are very much still alive, okay? So if we were looking for KIS, out of New York State, it's very plausible that he's still alive or she is still alive, and we could get this case. She could go in there, even though it's sealed and unpublished, she could go in there and get all these, he or she could go in there and get all this evidence for us. Number 12, the following court case was unpublished and hidden from the public. Indy Mac versus Bethley, 880 New York State 2D, 873, 2009. The court is concerned that there may be fraud on the part of the plaintiff or at least malfeasance, plaintiff Indy Mac, Duchess, and must have standing to bring this action. We've already been through that. Number 13, lawyer responsible for false debt collection claim, Fair Debt Collection Practices Act, Title 15, USC, subsection 1692, 1692-0, Hines, Hintz versus Jenkins, Jenkins, 514 US 291. Not answering calls, guys. I'm live streaming. 291, 115 S period, CT period, 1489. 131 L period, ED period, 2D, 395. The case happened in 1995. Very plausible that these people are still alive, Hines and Jenkins. And FDCPA Title 15 USC subsection 1692. Again, a declaration, a finding of facts authorized by Congress. Okay. 14, in determining whether the plaintiff come before this court with clean hands, the primary factor to be considered is whether the plaintiff sought to mislead or deceive unfair and deceptive trade practices, ladies and gentlemen, using Title 18, 1001, false and fictitious conveyance of language. Mislead or deceive the other party, not whether that party relied upon plaintiff's misrepresentation. Stanchen, Stachnik versus Winkle, Winkel, 394, Michigan, 375, 387, 230, N period, W period, 2D, 529, 534. 1975 was the case. Possibility they're still alive and kicking. Who knows? What can we talk about this case? In determining whether the plaintiff come before this court with clean hands. Clean hands doctrine, all right? In order to have proper standing, to bring a claim, you must come with clean hands, okay? Your intent is not with malice or to defame or to slander or to defamation of character, but you are coming in truth with light, pure intention to find remedy, and you are providing your information in good faith with good conscience and for good reason. That's clean hands, ladies and gentlemen. You have the evidence, the proof, and the standing to bring said claim. All right. And in determining this, they're determining whether the plaintiff did, in fact, come with clean hands to the court. If they didn't come with clean hands, if they were using a false and fictitious conveyance of language, a twisting of the language, if the plaintiff was the one who in fact created the contract using vague and ambiguous language, or a manipulation of the language, or false conveyance of the language, or failed to fully disclose the terms and conditions within the contract using vague and ambiguous language, ladies and gentlemen, the plaintiff did not come with clean hands, and thus this court has no jurisdiction over the matter, okay? The primary factor to be considered is whether the plaintiff sought to mislead or deceive. So how do we find out whether or not the plaintiff sought to mislead or deceive? Well, the defendant in this case probably should have filed in a small claims court case for $1 to establish the rights, titles, duties, and obligations of the parties. And then once the rights, titles, duties, and obligations of the parties was established through a declaratory judgment, they could have moved it into a different jurisdiction and venue where the defendant now becomes the plaintiff, if you will. the one that is aggrieved and now has a declaratory judgment based upon the fact that the contract was false, deceptive, and misleading, using vague and ambiguous language, or wasn't fully disclosed. Now that grants rise to the defendant, now being the plaintiff, having a claim for damages, okay? Harm, damage, and loss sustained by a false and fictitious claim being brought by the prior plaintiff that had no standing to do so because they didn't come with clean hands. Okay, the court isn't saying that he didn't come with clean hands. They're saying, hey, it needs to be decided whether or not this claim has been brought forward with clean hands. So they're kind of giving instructions to the defendant to go to a small claims court and establish the rights, titles, duties, and obligations, and whether or not the contract was written vague and ambiguously with false and misleading, deceptive trade practices, and false and misleading, vague and ambiguous language. The other party, not whether that party relied upon plaintiff's misrepresentation. So they kind of are acknowledging that the plaintiff had some misrepresentation here, but they're not really saying anything other than the fact that they're not going to rule on the matter because they don't believe that the plaintiff has standing, that he didn't come with clean hands, and because he didn't come with clean hands, they're just going to go ahead and shut the case down. Now, as I stated before, now the defendant should move. This is a game of chess, not checkers. Now the defendant knows that the court is seeing something that is drawing their attention, leading them to believe that the plaintiff does not have clean hands. Now the defendant should take action in filing a small claims court to establish, again, the rights, titles, duties, and obligations, okay? The validity of the contract. 15, indeed, no more than affidavits is necessary to make the prima facie case. United States versus Kiss, 658, F period 2D 526, 7th Circuit Court, 1981, cert denied. 50 U.S. L period W period 2669 or 2169 S period CT period March 22, 1982. Again, can Wells Fargo make an affidavit? No, it cannot. Can U.S. Bank make an affidavit? No, it cannot. Can a police department make an affidavit? No, it cannot. Can the state make an affidavit? No, it cannot. All right. These are all prima facie evidence. Can the district attorney make an affidavit? Sure he can, but is it valid? What do we mean by valid? What firsthand perfected knowledge of the facts does the prosecuting attorney have? Was he there? Is he a firsthand witness? Does he have superior firsthand perfected knowledge of the events that transpired? Or is he formulating a affidavit based upon hearsay, based upon somebody else's account of what transpired, right? These are important things for impeaching evidence, impeaching the witness, shutting down the fact that these people have a valid claim for which relief can be granted, all right? I hope this is helping you out. This is just all shit from the top of my head, and for what it's worth, don't take my word for it. Just go do your own research. 16, silence can only equate with fraud where there is a legal and moral duty to speak. That is a maximum of law right there. Fraud can only, or silence can only equate to fraud with where there is a legal or moral duty to speak. That, in fact, is a maxim of law that has stood the test of time for over 10,000 fucking years. It will stand the test of time for another 10,000 fucking years. And I think it's very interesting that this is the ruling of the court. I love using maxims in my writs. I absolutely enjoy using them because you just can't overcome sound doctrines, principles, and logic. It's very, very, very tough to overcome unless you're a fucking criminal. And then you're just saying, fuck you, we don't care what you say, kiss our ass. And now you've got grounds because, well, they're aiding and abetting criminal activity, perhaps, in some instances. Or when an inquiry left unanswered would be intentionally misleading. So when you're asking the government, do you register people as property, and they don't respond, they're being intentionally misleading, all right? They're leaving the inquiry unanswered, and because of that, you might have grounds for bringing a claim, okay? They have a moral duty and obligation to speak. Silence can only be equated with fraud where there is a legal and moral duty to speak. Now, the reason I asked that question of them, do you register people as property? Because if you don't register people as property, then who the fuck are you to give me a directive? Think about it. That would mean that if you register man or people as property, then you violate the 13th Amendment. Involuntary servitude shall not be had. It's a real tough fucking position for any agent and agency to be in when you ask them that particular question, all right? And they really want to skirt around it. They don't want to necessarily answer you. So there's a way to write it up in an affidavit where if they don't answer, they admit or they acquiesce that they either do not or they do. Or you can structure it in the form of a request for admissions where they admit that they do not, thus they don't have jurisdiction over you and their legislative edicts don't apply to you. It's just it's a matter, like I said, it's a game of chess, not checkers. It's a matter of just being stunning, cunning, and witty, not to defraud or deceive anybody, but really to expose the organization for what it is, okay? Number 17, if any part of the consideration for a promise be illegal, or if there are several considerations for an unservable promise, one of which is illegal, the promise, whether written or oral, is wholly void, as it is impossible to say what part or which one of the considerations induced the promise. Menominee, Menomine River Co. versus Augusta Spies, AUGUSTUSSPIES LN Co. Corporation, 147 Wisconsin 559 at page 572, 132 NW 1118. The case was had in 1912. What I'm gathering from this, and again, this is just my formulated opinion from reading a shit ton of information throughout the years, is that when they can't distinguish between the legal side and the illegal side of the aspect and two conjoining interactions that happen simultaneously, okay, whether orally or written, it's wholly void if any part of it contains any illegal transaction in the midst of the transaction. So if any part of that transaction be illegal, it's all completely wholly void from the beginning, in ab initio. So be mindful of the interactions that you're involved in. Make sure that there is no illegal aspect to the transaction because it would void everything. 18, Federal Rule of Civil Procedure 17A1, which requires that an action must be prosecuted in the name of the real party in interest. Now, I use this shit all the fucking time, baby. All the time. I lean on it. I weigh heavy upon it. Because why? It says, in the name of the real party in interest. Okay? The name, meaning first, middle, and last. 100% personally and commercially liable. All right, and how do we know that? Because they're using their full name. It also further goes on to say in Federal Rules Civil Procedure 17, their address, their email, their phone number. All those things must be on there. Why? Because if they bring a claim for which relief cannot be granted, bring fraud upon the court, slander and defame your name, use malice, ill will, bad intent that causes you a harm, you have a right to execute a private administrative process on them prior to airing your laundry in the public. One must try to execute due process of law, serve upon them in the private, and see if remedy can be had privately before you bring it into the courts and air the dirty laundry. All right? That's why a lot of people's court cases are thrown out. They never execute private administrative process. They never try to settle it on their own as men and women should. And they just bring their dirty laundry right into the public and go, okay, here it is, Judge. This is what happened. And the judge goes, wait a minute. You didn't serve them notice. You didn't give them an opportunity. You didn't fault them. You didn't default them. I don't see any affidavits in support. You don't have any evidence here before this court. All you're doing is dragging people in here and frivolously trying to sue them without giving them an opportunity to provide remedy for the wrong that they may or may not have done. So when the court is kicking it out, it's not that they're against you per se. They're saying, look, there's a proper procedure to substantiate that you have evidence and you didn't follow the procedure. And basically they're kind of scolding you. How dare you bring somebody in here and tarnish their good name without giving them any opportunity to provide remedy for a wrong that they may or may not have committed against you. See also in regard to Jacobson 402 BR 359 365 66 Banker WD Wash 2009 in regards to Wang HWANG 396 BR 757 766 67 Banker CD California. This case was had in 2008. 19 Mortgage Electronic Registry System. We know all about that. Incorporated versus Chong, 824 New York State 2D 764. This case was had in 2006. It involved MERS. Did not have standing as a real party in interest under the rules to file the motion. The declaration also failed to assert that MERS, FMC Capital LLC, or Homecoming Financial LLC held the note. Again, they're bringing fraud upon the court, claiming to be a real party in interest, not having an affidavit sworn to under the pains and penalties of perjury, nor being able to present any presentable or material facts into the court as evidence that they are the holder of the note. Okay? Which means they have no fucking standing. Can't tell you how many people have lost their house because they don't know how to articulate this stuff. They don't know how to stand up and go. And the reason I'm doing this, by the way, is the foreclosure mills are back and up and running and fully operational, and it's just a matter of probably another 6 months to a year before a lot of fucking people are getting hammered with this shit. So I hope this information finds you in good spirits, finds you well, you take it under consideration, you apply yourself and get ready if you're in that position for the last 2 years where you didn't pay your note because you were under the influence that COVID and this miraculous trusts were all going to be clearing everybody's debt. There's a number of them out there that people hang on to, you know, like a fleeting glimpse of hope. Nasera, Jasara, all these other things. Look. I ain't never releasing that to you guys. I ain't doing it. If you want a piece of that pie, you better learn how to assert yourself and make a claim. I ain't seen anybody do it yet. I can't attest that I have friends that have done it yet. As far as that goes, making claims against Nasura, Jasura, and all these other trusts that exist. They exist. I'm not denying that they don't. I'm just saying I've never seen anybody that made a claim to it that prevailed and walked away with their fair share of the pie. 20, Landmark National Bank versus Kessler, 289 Kansas, 528, 216, page 3D, 158. This case was held in 2009. Kansas State Annotated Code, subsection 60-260B, allows relief from judgment based on mistakes. Okay, so it looks like we're looking at a mistake, possibly a clerical error that was made in the court, right? Inadvertence, surprise, or excusable neglect. Newly discovered evidence that could not be, sounds like he's moving for a trial de novo, could not have been timely discovered with due diligence, fraud or misrepresentation, a void judgment, a judgment that has been satisfied, released, discharged, or is no longer equitable, or any other reason justifying relief from the operation of the judgment. The relationship that the registry had to the bank was more akin to that of a straw man than to a party possessing all the rights given a buyer. Also, September 2008, a California judge ruling against MERS concluded there is no evidence before the court as to who is the present owner of the note. The holder of the note must join in the motion. Now, I love cases like this, okay? This one's obviously published. We can go look it up. We can find it. We can see the conclusion. One of the reasons that I like it when a bank brings a foreclosure action is because when they're bringing that foreclosure action, they are admitting that you gave them something of value. So acknowledge and accept the fact that they are admitting that you gave them something of value. That way, when you say, can you produce that thing of value? Can you prove that you're the holder in due course and that you have proper standing before this court to move a claim? Can you prove that you are the party aggrieved for failed performance? Yes, we can. Great. Just go get that note and bring it here. Okay. Now, I don't want to argue about the semantics of the note and the signature and all that stuff. But what I want to point out is the fact that they're admitting by bringing a claim against you that you gave them something of value. A promise is something of great value. Okay. And now they're saying that they want compelled performance on that promise. However, the problem becomes if they don't hold the note. Well, Scooter, I'm sorry about your luck. Sorry about your luck. That's like trying to bring suit for your own ignorance and losing your own financial wherewithal. Yeah, I want to sue my friend Ted because I was in his car with the windows down and I didn't secure my financial wherewithal and it blew out the window and it's Ted's fault. I want to sue Ted now. And completely denying any of your own accountability and responsibility for making sure that your own assets were secure in the first place. It's a frivolous claim. It should be thrown out. I have no standing to bring claim against Ted because he rolled down the fucking windows and I didn't have my property properly secured or my assets properly secured and they blew out the window. It's my fault, not Todd's, not Ted's, right? So just think about that in that context to help you out a little bit. 21. LaSalle Bank versus Ahern, Hearn, 875, New York State, 2D, 595. This case happened in 2009. It was dismissed with prejudice, lack of standing. That case is not sealed. You can go look it up. It's LASALLE Bank versus Ahern, AHEARN, 875, New York State, 2D, 595, 2009. Again, it was dismissed with prejudice for lack of standing. I don't have any more credentials or details on said case. Novastar Mortgage Incorporated, NOVASTAR, Mortgage, MORTGAGE, Inc. versus Snyder, SNYDER, 3:07 CV 480, I believe that would be the cause number or case number, 2008. Plaintiff has the burden of establishing its standing. It has failed to do so. Again, I'll bet you they don't have an affidavit in support of the motion for bringing a claim or their cause of action for bringing a claim, and they probably don't have the note. And because of that, they have not established that they are the real party in interest having proper standing to bring a claim for which relief can be granted. Now, again, I don't have any more details on that case other than what I just read to you. So it would behoove you to go look it up. 23, DLJ Capital Inc. versus Parson, PARSONS. Case number 07MA17. This case happened in 2008. A genuine issue of material fact. Remember how I keep talking to you guys about presentable and material facts? That came from our brother David Ward, who met his untimely demise just about a year ago now. Very brilliant man. And he kept mentioning presentable and material fact. Presentable. Derek, where's the presentable and material fact? Everything that you're saying is speculation. Where's the presentable and material fact? It may be correct what you're saying, but I don't see it because there's no presentable or material fact. So take heed in those words because they have a lot of power, weight, force, and effect. The genuine issue of the material fact existed as to whether or not appellee was the real party in interest, as there was no evidence on the record of an assignment. Ooh, assignments and appointments. You gotta love assignments and appointments. Reversed for lack of standing, which means that the lower court ruled in the favor of DLJ Capital Inc. versus Parson. And Parson said, fuck you, you lying, looting, painter piece of shit that are intellectually inept and don't know what the fuck you're doing. I know for a fact that you made a ruling that is inconsistent with the law. So what did he do? He took it up to the appellate level on a brief. He put it before the appellate level. Now, it's very important that you understand that the appellate level, you don't get to talk. That's the importance of putting all your documentation in the lower court, because your documentation and your objections and taking exceptions to the things that are being overruled or ruled on that are not in your favor, and making sure that you object as an appealable issue. I take exception to it as an appealable issue based upon the fact that it's circumstantial, it's hearsay, it's There's a number of objections. Anyway, needless to say, you establish all that in the lower court. That way, when you get the brief to the appellate court, it reflects all the things you objected to. It reflects all the controversies that were created or bad rulings made by the purported judge or magistrate sitting on the bench that you believe are in error. Okay? I object as an appealable issue. I believe this court has made an error. I believe you, sitting on the bench, have made an egregious error that is causing I, a man, harm. And I object as an appealable issue and take exception to your ruling. Now, the appellate level can see your objection and understand why you objected. So it's not good enough just to say I object. You have to, the foundation for your objection must be noted, must be stated on the record, okay? And that you're taking exception to it as an appealable issue. You're letting them know right out the gate, hey, ding dong, I think you better go back into your fucking chambers and open up a fucking book and start to read. Because I believe you're making a palpable, egregious error at law, all right? One that I believe will be overturned when I hit the appellate court, all right? So the appellate court's looking at this case and going, yep, sure as shit. Old Parson, he was right. We've reversed for lack of standing. So they reversed the judgment of the lower court case decision made by some incompetent, inept judge, probably trying to line his pockets because, you know, they've got a duty to protect that public trust. And part of that public trust is all these corporations that are generating tax revenue, right? They've got an interest in that, believe it or not. 24, Everhome Mortgage Company versus Rowland, ROWLAND, number 07AP-615. This case happened in Ohio in 2008. Mortgagee was not the real party in interest pursuant to Rule 17A, lack of standing, all right? Very beautiful, that Federal Rules Civil Procedure 17A. This does not say Federal Rules Civil Procedure. It says Rule 17A, lack of standing. So now I need to go and do my due diligence, go into the Ohio Revised Code, look up Rule 17A, and see if Rule 17A has something to do with what they're referencing here, or if they're actually referencing Federal Rules of Civil Procedure 17A, which to my recollection and knowledge and study leads me to believe that's what they're rendering their decision on. However, we should err on the side of caution when we make a presumption and assumption, because it could make an ass out of you and me. So it would behoove us all to go look at Ohio Revised Statutes, Rule 17, and see what it says. Okay, because they might have made this ruling, this judgment, this rendering based upon Rule 17 of Ohio Revised Statutes. All right, so let's not just take what we presume and assume to know. Let's go do our fucking research and find out whether or not this was based on Rule 17 in Ohio or Federal Rules of Civil Procedure 17A out of the Federal Rules of Civil Procedure. 25, in Lambert versus First Star, FIRSTAR Bank, 83, Arkansas, appellate level, 259. This means it went up to the appellate level. They're saying that the lower court made an egregious mistake, a palpable error at law. They should have known better. But again, these educated idiots in the lower court are not always more intellectually savvy or knowledgeable than you. So it is our duty to gain this knowledge to ensure that they're not running amok over us, whether it be by mistake or intentionally. It's our duty to safeguard the liberty of the people, okay? And how do we do that? We become knowledgeable. 127 S period W period 3D 523 case was had in 2003. Complying with the Statutory Foreclosure Act does not insulate a financial institution from liability and does not prevent a party from timely asserting any claim or defense it may have concerning a mortgage foreclosure, ACA subsection 18-50 116D2. Now, I'm guessing that's Arkansas Code Annotated subsection 1850 116D2. The only reason that I'm saying that is because I look at a lot of these codes and I read through a lot of this shit, and I'm going to say that that is Arkansas Code Annotated. I could be horribly wrong on that. The beautiful thing is you have the internet. ladies and gentlemen, you could type in A.C.A, subsection 18-50-116D2, and tell me what the hell it is. And furthermore, you will know what it is, okay? So don't just take my word for it. This is just stuff that I got in my head from reading a shit ton of this stuff over the last 11 years. I kind of see it for what it is. I could be wrong in my assessment, so it would be best if you would go validate and check it for yourself. And violates honest services, Title 18, fraud. Now, honest services fraud. I fucking love Mr. Anonymous. He shared a deal about honest services fraud that was written by the American Bar Association. Shortly after he found it on the internet, he copied it and began to share it with a select few. And then he went back to go to the site that it was published from the American Bar Association, and voila, it was fucking gone. Now, this was a letter sent by the American Bar Association to all state bar associations, letting them know of the honest services fraud, and you may already be guilty of this. Now, he went to go collect the evidence, naturally, after he'd already downloaded it. He had the main frame of it, but he wanted to further collect the information and the evidence. And when he went back after downloading it, it was gone. These are the things they do when you start to take notice in their criminal syndicate ways, okay? Notice to credit reporting agencies of overdue payments, foreclosures on a fraudulent debt is defamation of character and a whole separate fraud. They're telling you right here, you got some type of financial institution in violation of honest services, which is clarified and classified as fraud under Title 18. You have grounds for a suit for defamation of character, okay? And I keep telling you that you have a right to your reputation, okay? And that right it grants rise to grounds for a claim for anybody who would slander, defame, use methods to receive ill-gotten gains by writing falsehoods about you. Okay, you have a right to protect your character. But they also say that it's a whole separate type of fraud. All right, title number 26. Court of Appeals does not consider assertions of error that are unsupported by convincing legal authority or argument. So again, when you're putting your affidavits together for motions to impeach, on the grounds to strike, motions for sanctions, you want to put your affidavits together in support of those motions for sanctions, the motion to strike, the motion to impeach, and you also want to put together a nice memorandum of law in conclusion with your affidavit. And then if you want to go the extra fucking mile, go ahead and make your argument on paper. You could also make your argument orally, but if you put it on paper, it's so much better because, again, the appellate court isn't going to hear your arguments. But if it's a written argument that's attached to the affidavit, that's attached to the memorandum of law in support of your argument, based upon your motion or your sanction or your motion to sanction, strike, impeach, whatever, now they can see it. Now they can grasp the concept of why you feel that the lower court has made a mistake, all right? So a court of appeals does not consider assertions of error that are unsupported by convincing legal authority or argument. So attach your fucking argument to your affidavit, which is attached to your motion to strike, compel, whatever it is, impeach, along with your memorandum, okay? Finding of facts, conclusion of law. Unless it is apparent without further research that the argument is well taken. Fraud is a point well taken. Lambert Supra. No lawful consideration tendered by original lender and or subsequent mortgage and or servicing company to support the alleged debt. A lawful consideration must exist and be tendered to support the note. And demand under TILA, full Truth in Lending Act, full disclosure of any such consideration. I'm just going to spell this one out because I can't pronounce it. Anheuser, Anheuser-Busch Brewing Company versus Ema Mason, 44, Minnesota 318, 46, N period, W period, 558. This case was had in 1890. Number 27. It has been settled beyond controversy that a national bank, under federal law, being limited in its power and capacity, cannot lend its credit by nor grantee the debt to another. So I think there's parts of this that are missing because the words are missing here. It can't extend its credit, nor can it guarantee the debt of another. All such contracts being entered into by its officers are ultra vires, and not binding upon the corporation. It is unlawful for banks to loan their deposits. Howard and Foster Co. versus Citizen National Bank, 133 S period C period 202, 130 S period E period 758, 1926. Number 28. Neither as included in its powers, not incidental to them, is it a part of a bank's business to lend its credit. If a bank could lend its credit as well as its money, it might, if it received compensation and was careful to put its name only the solid paper, make a greater deal more than any lawful interest on its money would amount to. If not careful, the power would be the mother of panics. Indeed, lending credit is the exact opposite of lending money, which is the real business of a bank. For while the latter creates a liability in favor of the bank, the former gives rise to the liability of the bank to another. I. Morse Banks and Banking, 5th edition, Section 65, McGee, Banks and Banking, 3rd edition, Section 248, American Express Co. versus Citizen State Bank, 181, Wisconsin, 172, 194, NW, 427. Case was had in 1923. I demand under the TILA, Truth in Lending Act, full disclosure and proof to the contrary. Number 29. UCC subsection 2-106-4, cancellation occurs when either party puts an end to the contract for breach by the other, and its effect is the same as that of termination, except that the canceling party also retains any remedy for breach of the whole contract of any unperformed balance. Note was lost, breach of contract. New York UCC Law, subsection 2-106, New York Code, section 2-106 definitions. Contract agreement, contract for sale, present sale, conforming to contract termination. Cancellation, 1. In this article, unless the context otherwise requires contract and agreement, are limited to those relating to the present or future sales of goods. Contract for sale includes both a present sale of goods and a contract to sell goods at a future time. A sale consists in the passing of title from the seller to the buyer for a price, section 2-401A. Present sale means a sale which is accomplished by the making of the contract. 2. Goods or conduct, including any part of the performance, are conforming or conform to the contract when they are in accordance with the obligation under the contract. 3. Termination occurs when either party, pursuant to the power created by agreement or law, puts an end to the contract otherwise than for its breach. On termination, all obligations which are still executory or both sides are discharged, but any right based on prior breach or performance survives. 4. Cancellation occurs when either party puts an end to the contract for breach by the other, and its effect is the same as that of termination, except that canceling party also retains any remedy for breach of whole contract or any unperformed balance. 30. There is no doubt but what the law is that a national bank cannot lend its credit or become an accommodation endorser. National Bank of Commerce versus Atkins, ATKINSON, 55 F period 465. This case was held in 1893. Number 31. National bank and or subsidiary mortgage companies cannot retain the note. Among the assets of the bank of the state bank were 2 notes secured by mortgage, which could not be transferred to the new bank as assets under the national banking laws. National Bank Act, Section 28 and 56, National Bank of Commerce versus Atkins, 8 Kansas Appellate Court 3054, page 8, 1898. 32. A bank cannot lend its money, but not it. A bank can lend its money, but not its credit. First National Bank of Tallapoosa, Tallapoosa versus Monroe, 135 Georgia, 61469 S period E period 11/23, 1911. 33. It is not necessary for rescission of a contract that the party making the misrepresentation should have known that it was false, but recovery is allowed even though misrepresentation is incorrectly made, because it would be unjust to allow one who made false representation, even innocently, to retain the fruits of a bargain induced by such representation. Whip versus Iverson, 43 Wisconsin, 2D 166, 168, N period W period 2D 201, 1969. So, the one who creates the contract shall not benefit from failure to disclose. There's a maxim, I can't remember it off the top of my head, it's really good, that speaks about people being able to benefit from their own mistakes, and it just simply cannot be had. So that is why the one creating the contract bears the burden of proof and also bears the disability and any loss for being vague and ambiguous in the contract and not fully defining and disclosing things. Just to confirm 21. What do you want on 21? There's 33. 21. Let me go back. We're at 33. 21. LaSalle Bank versus Ahern, 875, New York State, 2D, 595, 2009. Dismissed with prejudice, lacking of standing. So that's all I have on 21. That's LASALLE Bank versus Ahern, AHEARN, 875, New York State, 2D, 595. The case was in 2009. It was dismissed with prejudice, lack of standing. Get back down to 33. So he who bears the advantage also bears the disadvantage. So if you're the one that creates the contract and somewhere in that contract it was vague and ambiguously written, you didn't understand what you were doing when you wrote the contract, maybe you just simply made a mistake, because you would bear the advantage, you also bear the disadvantage, which means that they will not find in your favor because you created the contract and you had a duty to know. So the one who creates the contract also bears the disadvantage should it be determined later on down the road that the contract is written incorrectly or some part of it is written vague and ambiguously, and because of that, the one who creates it, bears the burden and the loss. 34. A bank is not the holder in due course upon merely crediting the depositor's account. Banks Trust versus Nagler, Nagler, 23 AD, A period D period 2D, 645, 257, New York State 2D, 298. The case was had in 1965. Again, a bank is not the holder in due course upon merely crediting the depositor's account, which means they also have to hold the note and the mortgage. To separate the note and the mortgage, there is no obligation, okay? That's what's so important about closing. The note, the mortgage, all its documents, all its contents must be sealed in that trust upon closing. They cannot be separated, all right? In doing so, the mortgage is void in ab initio. It coffers no grant of authority or no obligations arise from it. It's just simply void, all right? The court has no obligation to enforce it. If the court does presume to have the authority to enforce it, it's void. The other party has no obligation to obey. so on and so forth. This is all stuff you have to know. 35. Any conduct capable of being turned into a statement of fact is representation. All right. Statements of fact versus affidavit. I structure affidavits sometimes. I structure statements of fact in the form of affidavits. Sometimes we structure affidavits in the form of a negative averment. There's a lot you can do with it. It's just a matter of gaining that acquired knowledge so you can apply it constructively, properly, and yield the results that you wish to see. Any conduct capable of being turned into a statement of fact is representation. There is no distinction between misrepresentation affected by words and misrepresentation affected by other acts. The seller or lender, he is liable, not upon any idea of benefit to himself, but because of his wrongful act and the consequent injury to the other party. Remember when I said if you're the creator of the contract and the contract is determined to be false and misleading in some way, shape, or form that may give the advantage to the one who created the contract or even to the other party, the one who bears the burden, the one who bears the loss, is in fact the one who created the contract. Okay, so that goes along with what I was talking about earlier. Leonard versus Springer, 197, 532, period 64, NE 299. This case was settled in 1902. The older the law, the older the cases, typically the more earnest they are. All right. I love older law because it's more pure and genuine in most instances. So he is liable not upon any idea of benefit to himself. They're not saying because he benefited from it is the fact that makes him liable, but because of his wrongful act and the consequent injury to the other party. All right. So whether that was willfully, knowingly, and intentionally done, or by mistake or negligence, it doesn't matter. He is liable based upon that fact that he would have gained some benefit from the contract that was created by himself. And because of that, he is the party that bears the burden and the loss. 36. If any part of the consideration for a promise be illegal, or if there are several considerations for an unservable promise, one of which is illegal, the promise, whether written or oral, is wholly void, as it is impossible to say what part or which one of the considerations induced the promise. I believe that's actually a really long maximum of law. I believe I've seen that written in Plubert somewhere. And again, it's very interesting to see all these renderings and decisions made with these short, pithy sentences that are really maxims of law. They just make so much sense. So seeing justices or judges or whatever you want to fucking call them, rendering their final decrees and decisions based upon maxims of law should show you how powerful they are. Menominee, River Co. versus Augustus Spies, LNC Co. 147, Wisconsin, 559, at page 572, 132, NW 1118, in 1912. This is the last one I'm going to go through. It's short, it's sweet. I'm going to get something to drink, smoke me a cigarette, and relax a little bit. The contract is void if it is only in part connected with the illegal transaction and the promise, single or entire, Guardian Agency versus Guardian Mutual Savings Bank, 227 Wisconsin, 550, 279 NW 79. This case was had in 1938. We'll come back. I'll dig into more of these for you guys. Hope this is helping you out. Thanks for all your support. We'll talk to you real soon.